Hello students, today we are going to discuss the topic law relating to adoption in India. To start with the introduction, adopting a child is a legally and emotionally significant process that involves providing for the child's psychological, social and legal needs. The first adoption law to prioritize the child's welfare was passed in 1851 in Massachusetts, requiring a judge to determine if adoptive parents had the permission of the child's biological parents or legal guardian. Adoption was considered a state issue, not a federal issue, as the judge had final say over the adoption. Most adoptions stopped during the Civil War, contributing to the overcrowding of American orphanages. The New York Children's Aid Society proposed orphan trains in 1854 to relocate orphaned and abandoned children from urban centers to rural areas in the Middle West. These trains pave the way for contemporary foster care. Adoption is a common practice in India, with the Hinduism being the dominant religion. Epics and historical records have compiled information about saints and royals who were adopted or who adopted. The Ramayana and the Mahabharata are two great Hindu epics that include references to adoption. Adoption law in Smriti's texts focuses on the parents, not the adoptee. Adoption requirements for male children are spelled out in great detail in the Dharma Shastras. Students, the concept of adoption has undergone significant transformation with the advent of numerous laws involving the removal of a child from their biological family and their subsequent acceptance into a new family. While adoption has become a common practice for centuries, it wasn't until 19th century that it became formally legal. There is no uniform adoption law in India despite the country's many different religions. Students, the Hindu Adoption and Maintenance Act of 1956 is the only adoption law currently in effect for Hindu adoptions in India. Adoption is considered a more sacramental than secular act in Hindu law. Adoption serves twofold purpose. First, to ensure one's descent continues and to make sure that his or her last rites are carried out. Religions in India such as Islam, Christianity, Judaism and Parsis cannot adopt a child and give them their surname because they do not have their own personal law governing adoption. The Guardians and Wards Act of 1890 is the only law that allows them to take legal responsibility for the child. Students, the Hindu Adoption and Maintenance Act 1956 is followed by Hindus, Sikhs, Buddhists and Jains. The Indian government attempted to create a uniform law for adoption, but their efforts were unsuccessful. Now let us discuss adoption of children in Hindu culture, the Hindu Adoption and Maintenance Act of 1956 and related provisions. Only those individuals who meet the criteria for Hindu under Section 2 of the Hindu Adoption and Maintenance Act of 1956 are eligible for adoption and maintenance under the law. Those of other Hindu faiths such as Buddhists, Jains and Sikhs are also included in this description. Students, also since Muslims, Christians, Parsis and Jews each have their own legal systems, this act applies to everyone else. To the extent that the parents of a child who is raised as Hindu, Buddhist, Jain or Sikh are unknown, this act may also apply to that child. Students, females were not previously allowed to be adopted, but that changed with the passing of this law. The Hindu Adoptions and Maintenance Act of 1956 and its Amendment Act of 2010 have rationalized the scheme of adoption in many ways and have improved the status of women in taking and giving a child in adoption. She is no longer required to be a mere participant in the event. Her consent is required for a valid adoption by her husband, and she can initiate adoption in the same way that her husband can. Any single woman, regardless of marital status, can adopt a child. It is also possible to adopt a girl, but there is one caveat. If an adoptive parent already has a boy or a girl, they cannot adopt another boy or girl. The Hindu Adoption and Maintenance Act of 1956 also outlines the requirement for adoption in India, including the need for resources, mental health, legality, and the possibility of adoption under applicable law. Students, to adopt a child in India, a Hindu man must be at least 18 years old, of good moral character and financially stable. The adoption cannot proceed without the approval of his wife unless she has publicly renounced the word, abandoned Hinduism, or being declared mentally incompetent by the appropriate court. A Hindu woman must be of good mental health, of legal age in India, and financially stable. If married, her marriage must be dissolved, her husband must be dead, he must have publicly renounced the word and Hinduism, or he must be declared mentally incompetent by the appropriate court. The Hindu Adoption and Maintenance Act of 1956 specifies the types of individuals who can legally place a child for adoption. The father, if possible, with the approval of the mother. If both parents are deceased or have completely renounced the word, have abandoned the child, or have been declared mentally incompetent by the relevant court, the child's legal guardian may raise the child with the permission from the court. The court must be convinced that the adoption is in the child's best interest and the child's needs and wishes will be met by the adoptive parents. Students, according to the regulations passed by Central Adoption Resource Authority, that is GARA, Ministry of Women and Child Development, Government of India, eligible adoptive parents must meet certain requirements before they can adopt a child, including being of legal age to adopt, free of any conditions that could endanger the child's life, and having no criminal records or accusations of child right violations. Any two people who want to become parents can adopt a child regardless of whether or not they are married or have a biological son or daughter already. Single women are free to adopt children of either gender, but single men cannot adopt female children. Prospective adoptive parents' ages as of the registration date will be used to determine their suitability for adopting children in the following age ranges. To be eligible for adoption, a child must have at least a 25-year age gap between them and either of the prospective adoptive parents. In case of step-parent or relative adoption, the minimum age requirement for adoptive parents shall not apply. Only children with special needs, as defined in Clause 25 of Regulation 2, and children who are particularly difficult to place, as defined in Clause 13 of Regulation 2, will be considered for placement with families with 2 or more children who do not include biological or stepchildren. Students, in the case of Savan Ram versus Kalavanti, AIR 1967, the Indian Supreme Court ruled that a widow's adoption would be to both herself and her late husband, and the adopted child would be considered as a child of both the widow and her late husband. The Act abolished the doctrine of relation back by allowing a widow to adopt solely for herself and requiring an adopted son not to divest the interest already vested in another person in the adoptive family. The court also ruled in Sitabai versus Ramachandra 1969 that when a widow belongs to the family of her deceased husband, the child must also belong to the same family because new ties to the child are created with the adoptive family effective as of the date of adoption. Old rule of paternal relationship to an adopted child developed in classical Hindu law, but the old rule is neither confirmed nor revoked by an explicit provision in Hindu Adoption and Maintenance Act of 1956. The Act also abolishes the doctrine of relation back by allowing a widow to adopt solely for herself and requiring an adopted son not to divest the interest already vested in another person in the adoptive family. In conclusion, the Indian Supreme Court has established that the relationship with the deceased Hindu husband is established through adoption, but this does not mean that adoption is related to the husband's passing. It is important to distinguish between adoption by a widow and adoption by a divorced wife in this case, because the latter loses all the ties to her former husband's family after her divorce. A son adopted by a divorcee will not automatically become a member of the family of her former husband or, in event of a subsequent marriage, the family of her new spouse. Now let us discuss adoption under Guardians and Ward Act of 1890. Legally, adoption is not recognized by any major religion including Islam, Christianity or the Parsi religion. Even in the case of an informal adoption supported by custom, the adopted child will not receive inheritance rights and the adoptive parent will need to make a will or gift to the child in order to protect child's interest in the adoptive parent's property. Students, personal laws in India including Islam, Christianity and the Parsi faith do not recognize full adoption. In India, only Hindus can only take the guardianship of a child under the Guardians and Wards Act of 1890 as opposed to adopting the child outright. But a guardian does not have the same legal standing as a parent does with a biological child. In contrast to what was previously mentioned, adopted children do not have any legal right to inherent property under Hindu Adoption and Maintenance Act of 1956. A guardian-ward relationship is recognized under this act only till the ward reaches the age of 21. Adoption under Guardians and Ward Act of 1890 provides only guardianship rights to the couple so that they are not the child's legal parents but rather just guardians, and the child is free to leave them once he or she reaches the age of majority. After turning 18, a child's position in the family's inheritance hierarchy weakens, making him or her vulnerable to challenges from siblings and other family members. Now let us have a look on Islam's view on adoption. Adoption does not exist in Islam because it is forbidden by Sharia. Acknowledgement of paternity is the closest thing to the adoption in Muslim law. One way to distinguish between adoption and acknowledgement is that in adoption, the adoptee is legally recognized as another's son, while in acknowledgement, this cannot be the case. Unlike the Roman and the Hindu legal systems which recognize the adoption, the Muhammadan legal system does not. Adoption is not a valid method of establishing paternity under Islamic law. The Adoption of Children Bill was introduced to Parliament in 1972 with the goal of creating a single adoption law that would apply to all Indians regardless of their faith. However, the government withdrew the bill in 1978, rendering its passage impossible. In the case of Union of India versus Shabnam Hasmi 2014, the Muslim Personal Law Board raised concerns about the practice of adoption among Muslims on the grounds that it is prohibited by Muslim personal law. Despite this, the kafala system exists to protect kids. A Muslim cannot adopt a child under this system, but he can always become a kafil to the child and provide for the child's maintenance and well-being, including financial support for the child. Despite this, the child will be legally recognized as the biological parent's child. Kafil would not be considered an adoptive parent. The Supreme Court of India has ruled that the Juvenile Justice Act of 2000 as amended in 2006 is a secular law that applies to all people including Muslims, and that anyone can adopt a child under the law. This means that a Muslim can adopt a child even if his jurisdiction is Muslim personal law. A Muslim's ability to apply the Juvenile Justice Act of 2000 is not limited by existence of the Muslim personal law. A Muslim can either submit to the jurisdiction of Muslim personal law, in which case he cannot adopt a child, or submit to the jurisdiction of Juvenile Justice Act of 2000, in which case he may do so. It was also decided that the right to adopt or be adopted is not a basic human right in the modern era. The situation is not right for it to be a fundamental right at this time. And there are competing religious perspectives and practices involved. As has been noted, the broad object to such a declaration on the grounds that Muslim personal law does not recognize adoption, despite the fact that it does not forbid a childless couple to provide a physical and emotional care and protection to a child. Now let us talk about Parsi and Christian perspectives on adoption. Parsis in India, like Muslims, do not recognize adoption, but anyone can adopt a child from an orphanage with a court order thanks to Guardians and Wards Act of 1890. Adoption is not recognized in Christian doctrine either. Since adoption involves a child's legal allegiance, it falls under the jurisdiction of personal law. Christians, like Muslims and Parsis, have equal access to orphanage adoptions via Guardians and Wards Act of 1890, provided they receive the necessary court approval. Christian foster parents are the only ones allowed under the Act. At the age of 21, the ward can choose whether or not to continue living with his guardian. A child in this situation also has no legal claim to the inheritance. The validity of a Christian couple's adoption of a son came before the Kerala High Court in Phillips Alfred Malvin versus V.J. Gonsalves, AIR 1999. And the court ruled that the right of a couple to adopt a son is a constitutional right guaranteed under Article 21, and it cannot be said that the adoption made by the couple is invalid just because there is no separate statute providing for adoption. Because of this ruling, it is clear that a law of adoption is necessary for all Indians, male and female, who are denied the precious right to parenthood by their own legal system. The Juvenile Justice Protection and Care Act 2000, as amended in 2006, allows women to adopt orphaned, abandoned or surrendered children. The Act allows adoption of any number of children regardless of religion or marital status, or by childless couples or couple with biological children. If an Indian citizen is prohibited from adopting due to personal law, they can adopt under this Act. The adopted child is treated as same as a biological child for inheritance purposes. In the famous case of Union of India versus Lakshmikant Pandey 1984, an advocate's letter alleged unethical practices by non-profits and NGOs offering international adoption services, resulting in children falling into beggarhoods. The Supreme Court issued directives mandating the establishment of the Central Adoption Resource Agency, that is CARA, to protect adoptees' best interests. All international adoption applications must be supported by the country's Child Welfare Department, with the biological parent kept hidden. The government is also tasked with informing the embassy about the child's situation to monitor for signs of abuse. In the case of Rahasa Pandiani, deceased by legal representatives versus Gokulanda Panda, AIR 1987, a woman in this case adopted a child from sister of her late brother. After some time, the child died and the mother left her estate to the surviving family members. Several years later, a different individual filed a lawsuit asking a judge to rule that he was in fact the woman's adopted son. It was decided that irrefutable evidence must be presented in support of an adoption claim. For an oral adoption to be finalized, supporting documentation must be proved. In the case of Yaqub Lawai versus Gula, 2005, an individual claimed to be the adopted child of a couple entitled to a portion in their estate. The prosecution argued that the Islamic law does not recognize adoption, so he had no legal claim. The court ruled that the adoption is not permitted by Muslim law but may be allowed in cases where local customs allow adoption. The interest in the estate could only be created if there was an act or document proving property was gifted or provided to the individual. In the case of Srinivas Krishna Rao Kangu versus Narayan Devji Kangu, 1954, an adopted child in this case filed a petition seeking a division of his parents' joint undivided property. The defendants claimed that the adopted child's right extended only to the inherited property and not to the child's own work. The court ruled that when a child is adopted, the child effectively becomes the natural heir due to the legal fiction created by the adoption. If a Hindu widow adopts her late husband's child, the adoption has the effect of giving the child all the rights of a son retroactively, beginning with the date of the father's death. It was also decided that the adopted son is now legally entitled to his adoptive father's property. However, the rule of adoption is disregarded when someone makes a claim to another person's property. Once property is vested in an individual, it cannot be taken away from them under any circumstances. Now, let's conclude the discussion. The courts in India have catered to the issue relating to the fact that a Hindu couple who have already adopted a child under Hindu Adoption and Maintenance Act and already have a child of the same gender can adopt another child of the same gender under the Juvenile Justice Act of 2000. The courts have adopted a secular approach and allowed for the adoption of children under the Juvenile Justice Act of 2000, including those who had been neglected or abandoned. A policy was established for a special subset of kids. A child of the same sex as the natural child cannot be adopted under the Hindu Adoption Act, but the two acts must be interpreted in harmony. Adoption by a Hindu couple is possible under the Juvenile Justice Act if the child meets the criteria for the designed group of children. The most important aspect to be observed in cases of adoption is the welfare of the children and their overall holistic development. With this, we come to the end of today's lecture. Thank you very much for the patience listening. you.